today, who are joining us from different lands across Australia and different nations across Australia, and also to extend my respect to all other Indigenous people who are joining us from other places around the world, from their traditional lands. This is the third webinar in a series of webinars that we put together last year as a partnership between Youth Law Australia, the Australian Lawyers for Human Rights, and with the leadership of the Diplomacy Training Program. And I'm happy to see that so many of you have joined us during this dinner time. And I'm particularly pleased to see so many friends and colleagues and past participants in our webinars who are here with us today. Today, we're looking at the experience in Scotland in implementing the UN Convention on the Rights of the Child domestically. And my colleague, Dr. Faith Gordon from ANU College of Law will introduce our two distinguished speakers in just a moment. I would like to extend our respect to different Children's Commissioner joining us from Australia, the National Child Commissioner, Miss Anne Hollander, and from the Child Commissioner from Tasmania and the Northern Territory. Faith.
Hello, everyone. Good morning and good evening. I would like to acknowledge the traditional owners of the lands that I work and live on, the Ngunnawal and Ngambri people, and pay my respects to their elders past and present, and recognise that sovereignty was never ceded. So really delighted to be able to welcome both of our speakers and thank them very much for waking up extra early to participate today. The incorporation of the CRC into Scots law is a major achievement, and I'm sure that many of us tuning into the webinar will acknowledge that we've all been watching the strides forward that Scotland have been making. So it's wonderful to have our speakers today talking about that experience, and I'm sure that they'll be learning for lots of other jurisdictions. So I'm going to introduce, first of all, Bruce Adamson, the Children and Young People's Commissioner in Scotland. Bruce is a lawyer with over 20 years experience in human rights. He's also acted as an expert for a wide array of international bodies. And as Commissioner since 2017, his team has been and played a key role and been very responsible for promoting and safeguarding the rights of children and young people across Scotland. And working with groups of young advisors, they have helped secure legislative change in relation to the age of criminal responsibility, the physical punishment of children, and hopefully also then this incorporation of the convention into Scots law. And our second speaker, Megan Farr, has worked for the Children and Young People's Commissioner in Scotland for 5 years, and she has a background in social policy work in local government in England and Scotland, and most recently as the policy officer in a children's services department in the Scottish Council, focusing on education and social work. And her very recent policy work has included legislation on family law and domestic abuse, and also the impact of the pandemic on children, particularly in relation to their education. And she's been supporting the office in relation to the incorporation of the CRC into Scots law. So really delighted to welcome both of our speakers. Bruce is going to speak first, followed by Megan. So over to you, Bruce. Thanks again.
Thanks so much, Faith. Good evening, everyone. I'd really like to thank the Diplomacy Training Program, Youth Law Australia, and Australian Lawyers for Human Rights for inviting us here to speak with you all today. And Drs. Peleg and Gordon are both globally renowned scholars whose work I follow very closely. So thank you for that warm welcome, including that important recognition of the Indigenous owners of the land. And my strong thanks to all of you for that warm welcome. It's great to see so many people from across Australia and some international delegates. I understand that we're joined by colleagues from our sister independent children's rights institutions and national human rights institutions there in Australia as well. So it's my great pleasure to be joining you all. And as Dr. Gordon said, also my colleague Megan, who will be speaking as well. So in Edinburgh here, it's 8 a.m, it's -2 degrees, and we've had the biggest snowstorm that we've had in a long time. So there's about a foot of snow outside. So I suspect my lockdown emergency home education today will mostly be out playing in the snow but it's good to get this discussion done, so at least I'll feel a little bit productive. I was just going to say, I should probably explain that you might have noticed from my accent and Megan's that we're both originally from New Zealand, and I think we've never been more homesick than we have at the moment, but the days are starting to get a bit lighter, and I am optimistic about the future. I've got the best job in the world as Children and Young People's Commissioner for Scotland. I usually spend my days working directly with children and young people, climbing trees, sitting on the floor, playing with paints and glitter, marching and campaigning, and finding out what's really important to children and young people and helping them act as human rights defenders to help change the world. But COVID has changed the way that we work, but not the passion for that work. I've got significant legal powers to hold those in power to account and robust protections to ensure that I can't be removed from office when I do exercise those powers. So in our discussion today, Megan and I want to tell you a little bit about what's going on in Scotland in terms of progress on human rights, but we also want to make sure that we have a good discussion as well. So there's plenty of time for that. We've just celebrated the 75th anniversary of the United Nations and the 31st anniversary of the CRC in the middle of a global pandemic, which has disproportionately affected children whose rights were already most at risk, including disabled children, care experienced children, and children impacted by poverty. The impacts in terms of children's mental health, growing numbers of children facing bereavement, and the development impact on children has been catastrophic. Here in the UK, Brexit has also changed our domestic legal protections. Technological change is bringing challenges as well as opportunities in human rights terms. Across Europe, we've seen an increase in retrogressive attacks on human rights, yet young people are leading on things like climate justice, anti-racism, anti-misogyny movements, and they're highlighting the real failures of adults and our current system. So working with international human rights mechanisms and improving our domestic legal structures to protect human rights is absolutely essential. And as Dr. Gordon had said, the incorporation of the UNCRC into our domestic law in Scotland will go a long way in putting in place domestic legal protection, but there is a long, long way to go. For those of you not familiar with Scotland, we're a country of 5.5 million people, so about a fifth the size of the Australian population. Geographically, it's about 1/100th the size of Australia. There are about 1 million children in Scotland, spread over urban, rural, and also we have a number of island communities. Scots law has got a complicated history. It draws on Celtic and Roman roots. And unlike England, Scotland's maintained a strong system of Roman law of rights and obligations, as well as developing a common law similar to the English and Australian, New Zealand systems. So the Scots law system is often described as hybrid. So while Scotland's been united with England and the other parts of the UK since 1707, it's always maintained a distinct legal system. There is no UK legal system, and that's a very quick way to annoy Scots lawyers is to talk about the UK legal system, because there isn't one. There are 3 distinct legal systems. Northern Ireland has its own as well. So the relationship status between Scotland and the UK is complicated. Scotland's got a complex system where we're part of the UK of 66 million people. And for the best part of the last 50 years, we've been part of the now 27 member states of the European Union, which has about 513 million people. Important to note that Scotland voted against Brexit. But we're also part of the 47 member state Council of Europe, which covers about 820 million people, as well as the United Nations. And each of these bodies sets human rights standards which apply in Scotland, albeit that our relationship with the EU acquis is now somewhat up in the air. So the relationship status with Europe is very complicated. But we've got reporting relationships with the Council of Europe as well as the UN. And so strong engagement with UN treaty bodies and Council of Europe bodies. And while our focus is on promoting and protecting the rights of children in Scotland, we work very closely with colleagues across the Council of Europe area as part of the European Network of Ombudspersons for Children, which I have the privilege of being the current chair. So we play an important role in developing human rights standards at the regional and intergovernmental level. and at the UN level as well. And our young advisors are full partners in that work, right from the local community work that we do, right through to European institutions and the UN. Scotland gained its own parliament again in 1998, and since then Scotland's been responsible for pretty much all of its human rights decisions, some major exceptions being things like immigration and the military, and some elements of social security. But very much in the early days of the Scottish Parliament, there was a strong push to put in place human rights structures and protections and laws, including my own office, the Children and Young People's Commissioner for Scotland. It was one of the first pieces of Parliament legislation. So it was a committee of the Parliament rather than an executive proposal that created our legislation. It followed strongly the Paris Principles and the second general comments of the Committee on the Rights of the Child. And so it is a very strong legislation, although our resources are fairly limited. We have a budget of about £1.3 million. So that's just over £1 for every child in Scotland, and a staff of 15, bearing in mind that the number of children and young people in Scotland is 1 million. But we have strong powers of investigation, and we take action in terms of strategic litigation, strong elements of protection as well. I know that this is an expert audience, so I won't spend too much time on the rights framework, but I will start by saying that it's really important to our work that we set children's rights within the context of the wide array of international treaties and instruments that protect children's rights. And so while our focus is on the Convention on the Rights of the Child, we make sure that we look at all of the broad framework at UN, Council of Europe and European Union level, as well as domestic legal protections. And the focus of our mandate is up to 18 or up to 21 for those that have been in the care of the state. So care experienced young people up to 21 are included within our mandate. While there's a broad array of international instruments in relation to children and young people, the CRC is special. I often describe it as the most beautiful legal document ever created. I think it's amazing that we have this international instrument that starts with an idea that children should grow up in a family environment of happiness and love and understanding. It recognizes the inherent dignity and equal and inalienable rights set out in the UN Charter, and it really breathes life into the Universal Declaration of Human Rights. We all know that it's the most widely and quickly ratified treaty in the world. I won't go into too much detail around that, but rather move into Scotland. So the most important starting point, I think, in terms of children's rights in Scotland is our approach to involving children and young people. Not only is this an obligation in relation to Article 12 of the Convention, that children should have a say in everything that affects them, but it's an inherent part of the way that we work, is that children and young people need to play an important role in all of the work of our office, but all of the work of government decision-making. Children don't have the same political or economic power as adults, but they've got the right to be involved in decision-making. And that's something that we're not doing anywhere near well enough. I'm pleased that I work with a group of young advisors, and those young advisors advise me on every aspect of our work. They help develop our strategic plan, they help develop our budget, and they work at an international level as well. They helped lead our focus on thematic issues around poverty, mental health, and climate justice, which were our priorities set pre-COVID. COVID's changed that a wee bit. But also, really importantly, they've played a role in helping us engage with other children and young people. And that's been important at the domestic level, but also international level. When the former Special Rapporteur on Extreme Poverty visited Scotland, they helped us take him to Glasgow. And so one of my favourite memories is Philip Alston sitting on the floor in a primary school, half covered in paint, talking with children there about their experience of poverty, and then taking 4 of the 10-year-olds from that school to Geneva, to the United Nations, to work with the Special Rapporteur at the Human Rights Council on his reports his really damning report on the situation in Scotland and the UK in relation to poverty. And that was really important, that those children were right at the heart of that work. And poverty is the biggest human rights issue facing children and young people in Scotland. So it was really important that children's voices were at the heart of that. We've also involved children and young people in the Committee on the Rights of the Child. Of course, the work that we did in relation to the last day of general discussion on children's human rights defenders was really important to us, and around the recently approved General Comment 25 on rights in the digital environment. And we'll be looking forward to engaging them further this year, we hope, at the DGD, if it is able to go ahead on alternative care. So it's really important to me that children are seen in those spaces, but also other spaces at the United Nations as well. And in fact, when we went to the state report to the Committee Against Torture for the UK, my delegation was led by 2 young people. And I think that's a really important point, that children's voices need to be heard at all levels of the international system. Really important examples as well about children's involvement as human rights defenders. We've worked with Child Rights Connect and young people there to develop an implementation guide on child human rights defenders. And I really commend that to your attention. And we've seen children leading the way on things like the climate strike. Moving on now to some of our legislative intentions, and as Dr. Gordon had said in the introduction, the 3 big legislative intentions that I had when coming into office in 2017 were real concerns that Scotland was badly failing on a number of issues, particularly the age of criminal responsibility, the fact that Scotland still allowed physical punishment of children, and the fact that we didn't have strong domestic protections for children's human rights. And so the incorporation of the CRC, the age of criminal responsibility, and physical punishment of children were 3 strong priorities. It's worth noting that Scotland's got what's often described as a unique approach to youth justice and care and protection, which was developed in the 1960s, where children in conflict with the law and children in need of care and protection are both dealt with in the same system, which is a welfare-based system called the Children's Hearing System. I was a tribunal member in that system for 13 years, and I'd be very happy to discuss further. But despite having this system, which on the face of it looks really good, we were still seeing significant numbers of children and young people criminalized either through that system, picking up, going into that system on offence-based grounds, and then having that as part of their record ongoing, or being transferred from that system into the adult system, or children right into the adult system. We're in this awful position in Scotland where we have one of the lowest ages of criminal responsibility in the world. It is still 8. So Scotland's the only country in Europe where an 8-year-old can be treated as a criminal. There has been movement on that. The law has been passed to move that to 12, which is still well below what the international system expects. I understand in Australia that yours is mainly at 10, with some capacity tests up to 14, but certainly I understand there's been work done in some parts of Australia to change some of that. But really, really concerning that because of our children's hearing system, there were arguments against the age of criminal responsibility being raised, and absolutely concerned that there was very little appetite on behalf of politicians to change that. And so we brought evidence from the Council of Europe, the commissioner there intervened, Anne Skelton from the UN Committee on the Rights of the Child intervened. This was around the same time as General Comment 24 was being discussed. But both the Council of Europe and the UN had said for a very long time that 14 should be the minimum age, and that the countries that had an age of 15 or 16 was a much better reflection of children's right to dignity. And we know that using the criminal law to address harmful behavior by children is ineffective and breaches children's rights. It's not compliant with the intention behind Article 40, and certainly not something that meets the European standards set out by the Council of Europe. So it was a big disappointment to me that despite all of these arguments, we weren't able to make more progress, and we were only able to secure a change to 12. Equal protection, another big issue. Assaulting a child for the purpose of punishment should never be lawful. There's no such thing as a reasonable level of violence, and violence against children in one context risks tolerating it in others. And in 2017, the Scottish Government was opposed to changing the law. We had a law that allowed for reasonable chastisement, a justifiable assault by parents. Again, I made strong arguments and threatened legal action on this. It's not compliant with Articles 19 and 37, nor with Articles 8 and 3 of the European Convention on Human Rights. And so really big concern about that. And it was only through strong civil society action that we were able to secure that change in the law, which came into effect in November last year after a year delay. I am mindful of time, so I'm going to jump a wee bit ahead, but I think those two are really important issues. Poverty is my biggest thematic issue prior to COVID. 1/4 of children and young people in Scotland directly impacted by poverty, and we know that the devastating impact that has on mental and physical health and development and education and socialization. The work we did with the Special Rapporteur on extreme poverty, I think, was very powerful. Long way to go, and then COVID came along and made everything a lot worse, and I'll come back to that in discussion, I think. We've recently concluded an independent care review looking at care experience in Scotland. That was a really groundbreaking piece of work that came out with a call for significant and radical systemic change to the way in which we care for children and young people. That's now a year old, and the progress really hasn't come. It was a four-year process that led to really strong recommendations, but a year on, we're not really doing as much as we should, I think. In terms of the use of our strategic litigation powers as well, one of the big focuses that we'd looked at in terms of our investigation in strategic litigation was around restraint and seclusion of children and young people within educational settings. Also a big concern within custodial settings within the justice system. And so we're looking for significant change there as well. I'm going to pass, I think, to Megan now to talk a little bit about some of the legal structures that we've tried to put in place. And then I'll come back and say a little bit more about incorporation and a little bit on COVID before we move on to discussion, I think. So Megan, are you happy to jump in now?
Yep, that's fine. I'll just share my screen with everyone. Hopefully this will work because we tried it beforehand. I'm going to give a slightly whirlwind, and apologize for that, sort of trip through how children's rights have started to be implemented in service delivery. And in Scotland, both social work services and education services, and actually also other things such as housing, are delivered through 32 local councils. So a lot of the work to deliver services to children is going on in councils, either directly or through services they commission from third sector organisations. And I thought what I'd speak to you about was a policy called GERFEC, Getting It Right for Every Child, possibly the only social policy ever to have spawned a swear word, which I won't tell you. But GERFEC started about 15 years ago. It's had cross-party support across the centre-left of Scottish politics. We've got 5 parties in our parliament, 4 of which are centre-left. It originally started with a series of pilots, which was looking at making both child protection work, but also broader child support around well-being, mental health, and other services that were delivered by councils and by the health service more child-centred. The current slide is kind of the 2 starting points when the national GERFEC model went live. It's a practice model. It's designed to encourage multi-agency collaboration to support children rather than a siloed approach where different agencies are interacting with children and their families separately. So they started off with these two concepts. One is the My World Triangle, puts the child at the centre. Some of the things, and I apologise if it's quite small, some of the things in the My World Triangle correspond to children's rights, but rights aren't really there. And the same is the case in the round diagram. This is the well-being wheel. GERFIC became very much about well-being, which caused it some significant problems as a policy later on. The outer wheel, successful learners, confident individuals, effective contributors, and responsible citizens are the four key pillars of our curriculum in Scottish schools. I did get a certificate once where my child was a confident individual in religious education, which I thought was interesting. But the centre pieces, it's rather like a Trivial Pursuit piece, are what's called SHANARI, which is the wellbeing indicators: safe, healthy, achieving, nurtured, active, respected, responsible, and included. There are 2 R's, neither of them are rights, and it's included, not involved. So it's actually about overcoming social, education, physical, and economic inequalities. So neither of these had much of a place for rights specifically. It wasn't a place where rights were talked about, and neither had a lot of opportunity for children to be involved in decision making, which inevitably, if I get my slide to move on, led to this. UNCRC was somewhat backfitted into GERFIC as being the foundation for GERFIC. The document on the left, I'm pleased to say, has now been withdrawn. A colleague and I were chatting yesterday, and we both had to actually train people from this document, and it was clumsy. The circle on the right, you can see they basically tried to map different rights into the SHANARI indicators, and it wasn't hugely successful. And the big issue that arose around GERFIC is that people were talking in acronyms. They were talking about GERFIC and SHANARI, and rights were pretty much non-existent from it. So that all came to a point in 2014 where it was clear there needed to be some legislation to underpin some aspects of GERFIC. And there were some really great things. There was an idea around a single child's plan that would be contributed by all the different agencies. It would have put duties on different public agencies. At the moment, where a child is, for example, a disabled child, and there's a plan for their support, all the duties lie in education, even though they don't deliver the services. So it was quite a good development to get some legislation that would start to put obligations and to start to link them to rights. And we had the Children and Young People Scotland Act 2014. It put some duties on Scottish ministers. Rights were the very first section, part 1. Part 2 was us. We got some extra powers. Part 1 put duties on Scottish ministers in relation to the rights of children, and it also put duties on public authorities. Unfortunately, these duties were broadly to report and to have due regard. They weren't particularly strong, and they weren't in any way justiciable. However, what in Scots law was justiciable at that point was the European Convention on Human Rights. So first we got an Act of Parliament, and then we got a challenge in the Supreme Court of the United Kingdom, ultimately, on whether or not the Act of Parliament was compatible with the ECHR, which is a requirement of the Scotland Act. The Scottish Parliament can't pass legislation that's incompatible. Bruce is probably going to correct me on how I've worded that. But the judgment actually ruled that GERFIC was ultimately benign in intention, that generally it was okay, but that very specific parts of it were incompatible. The Christian Institute's arguments actually mostly fell. The bit that the court did agree with was an intervention by an organisation called Clanchild Law, who argued that the information sharing elements, which would have put duties about information sharing on public authorities for information sharing potentially without consent and below the threshold of child protection of a significant risk of damage to the child's welfare rather than well-being. That rather put everything into chaos. Ultimately, the Scottish Government have now repealed, without ever commencing, parts 4 and 5, which are the child's plan and the information sharing elements. So that is where we are, GOFIC is still happening. Information sharing is supposed to be happening on a consensual basis, unless it's a child protection issue. But the whole very quick fire through 10 years worth of saga has resulted in mostly we're all talking about Shannari. Quite a big industry built up. A lot of it was around this Shannari buzzword, the 8 well-being indicators. I don't have them on the screen. Oh, I do have them on the screen, so I could read them out. I can't remember them, and I've been working with them for 13 years. But what reaches children, young people and their parents is this discussion around Shannari. If you go on YouTube, there's some particularly cringy videos of adults doing songs and some slightly cuter ones of school assemblies with children doing songs about Shannari. There are several companies who are marketing the materials, and this is a selection of them. The little blue monkey, you can buy him. He can help you explain Shannari to your preschool classroom. You can also buy the cartoon characters on the bottom left. But my 2 favorites that I found when I was doing a bit of a trawl for this is the orange and multicolored thing, which is apparently a Shannari calamari, and the snail trail, which I saw that it had 53 squares and then a finished square, and I thought, oh, I wonder if that's anything to do with the UN CRC, which has 54 articles. It doesn't. It's a complete coincidence. So unfortunately, although the incorporation bill has started to change it, when you go and look at what's happening in schools now with children and with their parents, what gets talked about is still this jargony buzzword acronym Shannari. So that's one of the things that we're really hoping is going to change with incorporation, is we can start to talk about specific rights and children's rights in a broader sense, and move away from the discourse that's developed in the last 13 years. Thanks.
Brilliant. Thanks, Megan. A very kind of whistle stop tour of what was a
sorry about that. Not much time.
with what was a very long period of kind of policy discourse. Again, kind of acknowledging my own bias. I'm a lawyer, and I must admit, when I came in, I struggled with some of that, particularly the fact that within the curriculum of excellence, which sits underneath the structure, they talk about rights and responsibilities. The fact that rights isn't even mentioned within any of these core indicators, while many very many kind of smart people had tried to kind of fit them together, it really wasn't a rights-based thing at all. And in fact, in the policy consultation in advance of the 2014 Act, the Scottish Government's first consultation had said that it wasn't possible to incorporate the Convention on the Rights of the Child, which they quickly removed from that consultation document and changed it to it wasn't desirable. And despite the government saying it wasn't desirable, the majority of respondents to that consultation for the 2014 Act still asked for it. It's been a long-term campaign for decades now to get incorporation. And when I came in 2017, was working very closely with the Youth Parliament and others to really push this change. And I think we were probably quite surprised that the change happened. I think there's still, we're still surprised as to what really changed within government, that this significant change happened and they suddenly opened up to the idea of incorporation, to the extent that now we have a bill before Parliament which has cross-party support, and including from the most conservative elements of the Parliament, and is at stage 2 of our 3-stage process this week and is expected to pass next month. So what's really exciting, and I know we want to move into the discussion period, but I'll quickly run through the key aspects of the bill. It's broadly framed around our Human Rights Act, which brings into effect the European Convention on Human Rights. And so what it says is that all public authorities must act in compliance with the convention. It brings in some interpretive clauses as well to look at general comments, concluding observations, and also reports of the reports of days of general discussion. There's an amendment from government to bring those in, and communications under the 3rd optional protocol of the CRC as well. And so some strengthening around interpretation. but really strongly what it does is bring in an obligation to act compatibly for all public authorities, and we're looking to extend that to make sure that that covers what's set out in General Comment 16 as well, in terms of the role of private companies. So you can't outsource your obligation, you can't outsource any kind of responsibility. We want to catch everybody. Also, strike down powers in relation to in relation to existing legislation, and declaratives of incompatibility for future legislation. And then there's a whole bunch also of additional mechanisms, such as additional powers for my office to take action on behalf of children and young people, and then some also measures of implementation as well, like the use of impact assessments and the need for a children's scheme. So that's really exciting, and I'd be very keen to talk more about that. But I'll just end by saying a couple of words about coronavirus, which has hit the UK and Scotland very hard. The UN committee last year in April warned of the grave physical, emotional and psychological effects of the pandemic on children, and called on governments to activate immediate measures to mitigate those impacts. We haven't done anywhere near enough in Scotland, and so what we're seeing is significant rise in child poverty. We're seeing significant concerns in relation to child protection, and we're seeing a devastating impact in relation to particularly the mental health of children and young people. And so incorporation and the focus on it is really important. But what COVID has shown us is some real failures in things like decision-making and involving children and young people in decision-making. Very few of the decisions made in relation to COVID actually involve children and young people in any meaningful way. There was almost no use of things like impact assessments. And the impact on children and young people has been profound. So there's some real excitement in Scotland. We've banned physical punishments. There's some movement on age of criminal responsibility. We have a really fantastic law, which we will pass in the next month. But we have a really long way to go. And COVID's really shone a light on that, on things like child poverty, mental health, and youth justice. So sorry for taking much more time than we'd expected to, but I hope that was useful, and I really look forward to further discussions. Thanks.
Thank you both so much. I'm sure everyone will agree there was a huge amount of learning in both of your presentations and reflections. And I'm just going to get quickly into the questions now, because we've had a really active chat function box on this. So it's full of also people reaching out in terms of learning, and for the Queensland, for example, Family and Child Commission would like to get in contact with you all after. So lots of great learning, and hopefully future discussions as well. So firstly, Andre asked a question about to what extent does the general public in Scotland support and are aware of the human rights approach to the protection of children. So maybe Bruce, if you might be able to address that one for us.
Yeah, I think there's probably a general awareness. One of the interesting things about Scotland is because we have the children's hearing system, which was developed in the 60s. There's this kind of general awareness, but it's not really linked to an understanding of the international human rights framework. But there's a general feeling and sense that we take a rights-based approach. But when people think about that, they're probably thinking more about the Scottish approach rather than a link to kind of international human rights framework and a rights-based approach. But there's a general kind of acceptance and kind of positivity, which is probably different in Scotland than other places in the UK.
It's really positive to hear that. I've got a chapter in a book that I'd written, and the phrase children's rights is referred to as a bad words, bad phrase. So it's good to hear the positivity in Scotland surrounding rights. Megan, maybe you could address the next question, because you've also worked in a government department, I believe. So it would be useful to hear your perspectives on this. But can you share any experience in relation to advocacy for young people and children at the government level in Scotland? And maybe you could also make reference to the Commission and the work that you're doing there.
Can I just clarify, actually, is that advocacy with a capital A as in provision of advocacy workers or advocacy on behalf of or by children and young people? Because the provision of independent advocacy is a big issue in Scotland at the moment. We've done a lot of work in the office, and actually it was because of the structure of things in Scotland, it was local government that I worked in. And it's very different, I think, from Australia and New Zealand. It's local government that deliver social care and education. Health is delivered by regional health boards. So it's much more localized. Certainly in the last 15 years, the role that children and young people are playing in decision making has increased, and there's been some really good examples of increased practice that allows direct involvement of children and young people in decision making, particularly the champions boards, which were set up around care experienced young people in local authorities, those young people are well supported, and they're having a big influence on policy. At a Scottish government level, we're very lucky in Scotland to have a really active youth parliament. They do like to remind people they are one day older than the reconvened Scottish Parliament, so they've been around since 1999 as well, and they have a lot of interaction with the Scottish government. And together with Children's Parliament, which is a slightly differently structured organisation, but works with younger children, roughly primary school age and a little bit older, they have an annual cabinet meeting with the cabinet of the Scottish Government, so with the First Minister and her ministers. So that is some of the ways in Scotland that young people have a role directly engaging with government. Bruce probably would like to come in on some of the work we've done around other young people. If anyone would like me to talk about advocacy, I can do that at length as well. But I think that was what the question was asking.
Thanks, Megan. Bruce, do you want to add anything to that? Or I have another question that maybe you could address if you don't mind.
Go.
What do you expect to be, so Meta is asking, what do you expect to be the impact of the incorporation bill on the advancement of socioeconomic rights of children, especially as far as adjudication by courts is concerned?
Yeah, this is the big change. This is the really big change. I would start by saying that our argument throughout has been this isn't about litigation. This is about culture change. And so the fact that we've got the power to litigate and to hold to account will change culture. And that's been the experience in countries in Europe, and kind of particularly some of the Scandinavian countries and others who have incorporated much earlier, is that it leads to culture change because of the potential to be held to account. But what the big change will be is socioeconomic and cultural rights, because most civil and political rights are already incorporated through the Human Rights Act in the UK, and which is included within our constitutional settlement. So we've already got some kind of litigation, people using the European Convention on Human Rights. The CRC is stronger on civil and political rights for children, which is great. But what the big difference is going to be is exactly as the question is framed, on economic, social and cultural rights. So what we'll be really expecting to see, particularly around issues like poverty, and really using, I think, arguments linked to Article 4 in terms of use of available resources, that's where we're really going to see the biggest change, and certainly where our attention will be focused. That said, we've strongly given in our evidence that we don't intend to be constantly litigating. What we expect to see is culture change, and the use of impact assessments, and the use of a rights-based approach to change. But it is the potential is there, and certainly additional powers from my office as well. And our attention will be strongly focused on those economic, social, and cultural rights, which aren't currently incorporated into our domestic law. So that's going to be the really big change. But the push is for culture change on those issues. And the response we've had from public authorities has been really positive. There is an understanding there that they need to change the way in which they approach things.
Thank you so much. We're getting lots of questions in now. And lots of people are putting up about their experiences as well. We've got some examples here from lots of different places around the world. There's a really great point that's been made by a law student. So Diane, thanks for your point. And it's really about kind of the potential benefits and impact that having the convention incorporated into domestic frameworks could have in terms of, you know, challenging. So I think it kind of links to what you mentioned there earlier, Bruce. In relation to this cultural shift and change that you hope to see in Scotland, I think it's fair to say that in other countries and jurisdictions, we would also like to see a cultural change in relation to, you know, how we view children's rights and children themselves. Have you any kind of solid examples really that you have seen a shift in relation to, whether that be government departments or particular agencies in relation to the voice of the child? And that might link to some of the participatory work that you've been really key in developing in Scotland.
Yeah, we've seen a big change. I'd kind of caveat that by saying that COVID's really, I think, shown the vulnerabilities of that. But the examples Megan gave, we've had a youth parliament, which has been really effective over the last 30 years, children's parliament, which is a centre of excellence in children's participation, and them and broader civil society have worked very closely at local authority level and government level, to the extent of having annual cabinet meetings, at local authority level, children's services planning, lots and lots of kind of good participation events led by real experts in child participation. And again, as Megan mentioned, the setting up of champions boards, so care experienced young people at almost all of our local authorities now, or well, significant number anyway, helping to shape policy. So what we've seen is some of the structures being put in place, which is really useful. Where we haven't got to, though, is that leading to really clear change. So particularly in things like budgeting. And so what we've seen is children and young people being much more involved at every level in relation to children's issues. But what we haven't seen is the broad cross-government support on things like transport and budget setting and planning. Children are still not seen in those spaces. And again, the kind of depth of it, actually tracking through that change, having kind of budget responsibility, having those feedback loops. Our office developed a set of golden rules based on Laura Lundy's model, which we've been actively promoting. And so there are some specific examples of good practice within local authorities where we have actually seen children kind of involved in budget discussions or planning discussions, but it's still very limited. And then I think over the last year with COVID, one of the really disappointing things has been to see just how vulnerable that really was, because children have been pretty much ignored for the last year. And I think that shows how far we've got to go. So lots of good practice examples, but we still haven't embedded it, I think, at a systems level yet. Incorporation will change that, because our strong arguments will be, unless you do that, then the legitimacy of your decision making is subject to challenge. And so children's participation, the use of impact assessment and impact evaluations, we would see as two of the main things that public authorities will need to do. Otherwise, we will be challenging them.
Thanks, Bruce. Greg has asked a question about raising the age of criminal responsibility to 14. It's being advocated here in Australia by the Law Council of Australia and Indigenous leaders, and it's being discussed by the Australian Council of Attorney Generals. And as Greg notes, the sticking point is with the appropriate way to deal with serious offences that are committed by children that are younger than 14. Does your, and he mentions there about the criminal justice and welfare models, does your experience suggest a model which is appropriate for addressing this issue?
Yeah, I mean, our children's hearing system, I think could be strengthened, but does already deal with serious harmful behaviour by children and young people. And all of the evidence from countries with higher ages of criminal responsibility show that taking a welfare-based approach is the best way to ensure non-repetition, to ensure all of the aspects of kind of justice. And I think that's a really important part of this conversation, is around victims of crime, majority of which are children in relation to this. And so making sure that their voices are heard. And when we look at what an effective remedy looks like for them, things like non-repetition and apology and things are a really important part of that. And if we strip out kind of those elements of what we're trying to achieve through youth justice, we're really just left with that kind of punitive element of punishment. And I think that we need to take that out of the equation. What I would say is that this has been probably the biggest failure for me over the last 3 years. I wasn't able to convince our parliament to move it past 12, and that was hugely disappointing because all of the evidence shows that that's the wrong decision. The government tried to kind of sneak this through just before the 24th general comment was approved, based on some misunderstanding that because the general comment that said 14 hadn't been adopted, that was some way of kind of getting around it. But the committee for a long time has said that at least 14. The Council of Europe has said as well. Many countries in Europe have higher ages, and those that have got 15 or 16 have got really strong evidence around taking a different approach. We've been discussing a lot around the kind of Barnahus system, particularly in relation to sexual and violent crime, and the models that they have in Iceland and Scandinavian countries, where they provide really intense support to those children that are displaying harmful behaviour and that have hurt others, as from a welfare point of view, delivers much better results. And I think that needs to be the real focus: is what are we trying to achieve here? Certainly in terms of respecting the rights of the child, in terms of respecting the dignity and reintegration and all of the stuff that we know well from the rights framework. But the evidence framework also shows that taking a welfare-based approach is the best way to ensure against recidivism, and actually meeting the aims of justice in terms of that kind of non-repetition, in terms of being able to get to some level of understanding and perhaps apology and things like that. So we really need to change the way in which we approach harmful behaviour for children and young people. And it really does worry me that our parliament stuck at 12, even with the overwhelming evidence that was presented that there were better models. And even though we have a children's hearing system that could have overnight been able to pick that up, we didn't even need to develop a new system. And Anne Skelton, from the Committee on the Rights of the Child, who's a South African lawyer, I'm sure you all know her really well, when she gave evidence of the progress in South Africa, said they were at a disadvantage because they didn't have a welfare system ready to go. So they needed a bit more time to raise their age because they would need to put in place a system. Scotland didn't. Scotland's got a system that would have been able to, and already does, deal with many children with harmful behaviour, including very serious harmful behaviour. So yeah, I'm hugely disappointed. The answers are there. There's countries that are doing so much better. The evidence is just overwhelming, but it does worry me that we still have this kind of very kind of punitive streak within political discourse in relation to criminal justice.
Thanks, Bruce. We've got a question from Georgina about the context of the pandemic. And so Georgina says, Bruce, you referred to children's participation during COVID-19. What needs to change to better respect and protect children's right to participate in decision-making in various settings in a global pandemic? And also, just if I can bolt on to that, through your work kind of in the European context, is there any learning that has there been engagement between the commissioners elsewhere about you know, what they're doing in their particular jurisdictions as well? And do you kind of share approaches and knowledge in that space as well?
Yeah, I mean, so the ENOC's great, the European Network of Ombudspersons for Children. So there's 43 of us across Europe. We're in daily contact. The Bureau of ENOC had a meeting with a number of the vice presidents of the European Union yesterday to discuss exactly this topic, children's participation and development of their work. So it is great, the kind of solidarity that we have, and particularly during COVID, we are in daily contact, sharing information. I also sit on a World Health Organization advisory group, which is able to draw in a lot of really important information from across Europe. So that's really positive and useful. In terms of children's participation in Scotland, but also at international level during COVID, the government arguments, which I have no time for, where we need to make decisions very quickly, and these are really technical issues. It's like those things are true, but they don't prohibit children's participation in a process which has now been going for a year. And at its most obvious, children weren't consulted on what learning should look like during lockdown, on how remote learning should function, on return of schools, on exams. And this was a real major issue for our older young people who are going through assessments. exams being cancelled, no consultation on what alternative mechanisms for recognizing their achievement. Those things would have been really easy. Those things would have been really easy. There's already mechanisms set up of the Youth Parliament and others and youth boards. They now have a couple of members of the Youth Parliament on the government's advisory education recovery group. But all of the systems that we'd already set up at local authority level and government level to engage with children and young people all just stopped. And they could have maintained those, and they could have included those. COVID and the kind of epidemiology of it and the public health response to it, yeah, there are some complex technical elements in it, but if politicians can understand these things, then children and young people can as well. And part of the obligation is to be able to communicate in a way that children and young people can meaningfully engage. And I think particularly when it came to education, particularly the impact on things like socialization, on poverty. So one of my biggest concerns had been poverty and mental health. Two biggest concerns pre-COVID, massively increased since COVID, and children and young people weren't consulted and weren't involved. Only by knowing their experience can we have effective policy responses to that. And so how do we get financial support to families? What should that look like? Should that be food? Should that be direct payments? And what type of technology do children need to engage effectively? What are the impacts on mental health? Children have got the expertise on this because they're living through it. And so we should have used the systems that we already had in place to make sure that we got that information. And that's not just big surveys, that's actually children being involved. And as we are now right across the globe having a digital conversation, that can happen so easily at the moment. And the idea that decision makers didn't involve children and young people, I'm speaking to children and young people every day at the moment through this mechanism. It's no substitute for real life contact, but it's inexcusable that decision makers didn't make use of these types of mechanisms to get children's views in relation to decision making.
Thank you so much. And thank you both, Bruce and Megan, for your presentations and also for following up on the questions. There's been lots more in the chat box that I'm sorry we haven't had the time to cover, but we've had lots of links posted in the chat box, so hopefully those resources will be useful for people. I'd really like to thank you both. I'd also now like to pass over to Matthew Keeley from Youth Law Australia, who's going to conclude the webinar for us. Thanks, Matthew.
Thank you, Faith, and thank you everyone for coming. Can I just say congratulations. Tonight there have been 83 attendees, and of course we did have 190 registrations for tonight's webinar. So we can definitely say that there's an appetite for this event and others like it that help us to understand the CRC and the committee's recommendations and to implement them in practice, and indeed in all of our practices. Present tonight, we have colleagues from across the Indo-Pacific. We have state, territory and national leaders in diverse areas of law, policy and practice relating to children. We have practitioners, academics, students and young people. We're from government, NGOs, commissions, educational institutions, and we have interested members of the public. And this safe place for coming together at the initiation of the Diplomacy Training Program, the DTP, is really at the heart of the DTP's mission to create more effective human rights dialogue between government, civil society and the private sector. It is a credit to the DTP and the vision of its founder, the Nobel laureate Jose Ramos Horta, that Patrick and his team continue to find these opportunities for safe places where government and civil society can come together and discuss human rights without the usual adversarial or conflict type approaches. In that regard, I'd like to thank Commissioner Adamson and Megan again. The issues of time zones, taking time out of their own busy schedules, sharing their experiences and practice wisdom with us across the other side of the globe. It's the very essence of what the UN human rights system means when it often talks about and encourages international cooperation. So thank you. It was so interesting to hear you talking about making rights central to the development of law and policy in Scotland. Children as human rights defenders, children as co-authors into a report on poverty, children at the UN itself, and children's voices being heard at all levels, albeit quite sadly, that was obviously reduced during the time of COVID. So many positive stories, the welfare-based approach that is the children's hearing system, and of course, warnings of unintended consequences, that such a good system also supported arguments against raising the age of criminal responsibility. A society in which care responsibilities extend to age 21, and such significant participation forums and events for children and young people. And your priorities, age of criminal responsibility, physical punishment, incorporation of the CRC and participation of children during COVID. Your powers, strategic litigation, other actions on behalf of children and young people, all directed to changing culture. I think we can learn, and our diverse commission and guardian structure in this country can also learn from the statutory and practice framework in Scotland. So again, I thank you. Thank you to my colleagues, Drs. Nom Pellig and Faith Gordon. Nom and Faith are both very involved in educating the next generation of children's lawyers, and we thank you again for your time and expertise. Again, to my colleagues, Patrick Earle, Claire Sidoti and Andre Frankovitz at DTP. Claire and Andre in particular have worked tirelessly to ensure the success of our webinar series. And of course, the organisations that support the individuals involved in this initiative, UNSW Law and Justice, the Diplomacy Training Program, Australian Lawyers for Human Rights and Youth Law Australia, all of which volunteered their time and resources to support this initiative, and long may it prosper. And to you, our attendees, your insightful questions, comments and contributions have ensured that we have all grown in understanding tonight, and I thank you for attending. I'm going to ask you all to join with me in applause, which will require you to unmute. So if you could all just unmute so our colleagues and friends can hear our applause. So before we... and may I lastly mention that this is part of a webinar series and another is taking place next March. We also hope to recommence the face-to-face workshops, which were the origin of this particular program, and which of course were put on some hold during COVID. But please stay in contact with DTP and you'll be hearing more about that in your email, no doubt. We also have a short 2-minute feedback survey, which we will be sending out to you. And we would appreciate if you would take the time to fill them in, because it's our fervent desire to continue to serve our colleagues globally, but in particular in the Indo-Pacific region and in Australia and in New Zealand and elsewhere across the globe in essence, but particularly in Australia. And we would love to hear from you what you would like to see in our future webinars and how we can indeed improve them. But given that there can be no improvement, that Bruce and Megan gave us such an excellent understanding of the situation in Scotland and how we might build on those learnings here. I'd like to again thank you both, and on that behalf, I'll pass back to Faith, I think, to close the meeting, so to speak. Thank you, Faith.
Thanks, Matthew.
I think Matthew has done a wonderful summary and conclusion there. So I wish everyone, Megan and Bruce, a lovely rest of your day, and everyone else a lovely evening. So take care, everyone, and thank you again to all those involved.